what is the test that the Trademark Office is considering when they're trying to make this decision of should we refuse a mark on the basis of immoral or scandalousness? And generally it's, would a substantial composite of the general public find the mark shocking or offensive? But just as Paul pointed out, that was administered very inconsistently. And you can see with the thumbs down, these were some marks that were refused based on this provision. And the thumbs up were the ones that were approved. And you can see it's not necessarily so much of a difference between the ones that were refused and the ones that were approved. I mean, some even that have a positive message, like FUCK cancer, were refused, and then some that have like it's obvious what the phonetic equivalent of FU is, were approved. So in the arguments considering is the prohibition unconstitutional, the government says no. I mean, the Lanham Act only bars registration. We're only talking about whether people can register their marks. We're not talking about whether they can use them. But it's interesting because at the same time as making that argument, they also talked about how, as Paul also pointed out, they argued in Matal v. Tam, the government has an interest in protecting viewers from encountering offensive material. So on the one hand, they're saying, well, we're not really impacting these applicants. We're just saying they can't use it. On the other hand, they're acknowledging that there is some marketplace impact from denying registration. And also, you know, the government argued they have an interest in not being associated with certain scandalous speech, because our government would never say anything scandalous. And finally, they said, look, okay, all right, it's very broad. We may have made some mistakes in the past in the way that we interpreted this, but going forward, we're going to really just read it very narrowly. We're only going to refuse marks that are truly lewd, profane, and sexually explicit. So on the other side, Mr. Brunetti arguing, is it unconstitutional? Yes. One case that kept coming up in these arguments was the Cohen case. The Cohen case was a 1970s case where Mr. Cohen wore a jacket into a courtroom that said FUCK, the draft. And he was brought up on criminal charges for doing that. And it went all the way to the Supreme Court. And the court said, no, he shouldn't be punished for this. This is an offensive speech, but it's an important one for people to hear. So we've seen that offensive speech can have some value in this country. And, Brunetti argued it's not a content neutral rule. It's not that everything that references profane words is being refused. As we saw, it's being applied very selectively. And the statute on its face is problematic. The way the test is written is very problematic. We're looking at whether a substantial composite of people would find this offensive. Well, a substantial composite of the population are vegetarians, and so they would find Steak and Shake to be immoral because it promotes eating steak. So the justices in deliberating this, they were very concerned about opening the floodgates for profanity and obscenity in the marketplace, which again kind of points to the fact that there is some connection between marketplace usage and registration. They were also really concerned about, do brand owners under the current statute have adequate notice when they're developing a brand of whether I'm going to be able to register this or not, whether I'm going to be refused or not? And even if everyone can agree that the statute as written is very broad and it's been poorly applied, do we really want to have no line at all as to what can be registered and what cannot? And they also had a very difficult time parsing out these lines between what is a disparaging mark, what is an immoral or scandalous mark, and what is something that is a protected viewpoint like Mr. Cohen's jacket. So the decision came out, and the justices found that the statute was viewpoint discrimination. The government can't discriminate on speech against speech based on the ideas or opinions it conveys. And I thought this quote really captured it. The Lanham Act was permitting registration of marks that champion society's sense of rectitude and morality, but not marks that denigrate those concepts. So good moral speech can get registered, bad immoral speech not registered, and the justices found that was discriminatory. So also an interesting point that came up in their decision is it wasn't just, we're not just talking about curse words here in the scandalous or immoral arena. And they looked back at how the statute was applied on other topics like drugs, religion, and terrorism. So, for example, marijuana cola was refused and cocaine were refused for beverages on the basis that they are glamorizing drug use, where dare to resist drug violence and say no to drugs, reality is the best trip in life, were approved. Bong hits for Jesus was refused as potentially offending Christians, and Madonna for wine was refused as potentially offending Catholics. But praise the Lord and Jesus died for you were approved. So you can see these are kind of weird decisions for the government to be deciding, what is able to be registered and what is not. And even on terrorism, maybe Al-Qaeda for clothing was refused, whereas the War on Terror Memorial was approved. So as to the government's argument about look, we'll just read it more narrowly going forward, the justices said, we can't trust you to do that. We can't just assume that that's going to happen. That's not what the statute says. But Congress could enact a new statute if that's what they choose to do that is a much more narrowly tailored one. So I guess with that, I'll pass it off to Doug. Let's just talk about what's next.
Just before you do, I thought it was really interesting that you mentioned that Brunetti has this anti-capitalist kind of market that he's trying to appeal to, when there was a T-shirt that was on one of my slides that they're now selling that said IFUCT, the Supreme Court, and I just kind of perused the website, and they're selling that T-shirt for $125. Nice. So I thought that was really interesting. And the other thing is the logo. I'm really surprised, and maybe this has come up before, that Ford hasn't made some kind of comment about dilution or trade dress infringement, because it seems like they would have at least a claim, not that they would prevail, but it's really interesting that this trademark matter has all these other implications there.
Yeah, I mean, I tried to get one of those T-shirts to wear today, and it was completely sold out too. So popular.
All right, so I'm batting cleanup, and my first job today is to augment the salaciousness quotient that you've been subjected to already. And the way I thought I would do that was to sort of go back to 1978, when the U.S. Supreme Court decided FCC versus Pacifica, the case involving George Carlin's famous 7 dirty words routine, which the court ultimately concluded could not be aired during primetime television, and see what the registration and application status was for each of those 7 words. We begin, of course, with S, which stands for an excretory activity. That one, there had been 236 applications filed with the USPTO. Only one was registered for the word shitz, interestingly enough. There's the P word, which is another form of excretory activity. 16 applications, 8 registrations there. So I guess that's somewhat more in vogue these days. There is, of course, the famous, as we've been talking about with Brunetti, the famous F word. The F word had 232 applications, including 12 for FUCT, and no registrations, and this is all as of July 31st when I last checked. There is the C word for female genitalia, 4 applications, 0 registrations. There's the C word for the male anatomy and the activity that Linda Lovelace engaged in Deep Throat. That had 0 applications. There's the MF word, mother plus the F word, 3 applications, 0 registrations. And finally, the T word for female breasts, 39 applications, 13 registrations. There are a couple of other less dirty words. One involving the male chicken. That had 177 applications, 116 registrations. Slant now had 50 applications, 38 registrations, including the slants. I checked on kike. 1 application, but no registrations. Hebe, as Paul mentioned, had 2 registrations, had 2 applications, 1 registration. The N-word has never been, no applications have ever been submitted for that. However, the word NIGGA has had 10 applications and 0 registrations. So what's my view on sort of the takeaway from these 2 cases and the PTO's history in this regard? Well, I think that the decision may, at least initially, result in some increase in the use of crude or vulgar trademarks. But it's also possible that brand owners may be concerned, rightly, that the proliferation of such marks will offend significant segments of their market. And I don't believe, as a consequence, that major producers of goods and services are likely to want to register such marks, just like they haven't availed themselves of the opportunity to use those marks in commerce without bothering to register them at all up until now. But I do think that once the taboo against registering such trademarks is removed, that lesser-known brand owners may no longer view such marks as sufficiently edgy. And the reason why I say that is that we have a few sort of historical examples of what happens when you try to ban things. There is a story you may be familiar with in the Garden of Eden when God tried to ban the tasting of a particular fruit. And we saw what happened as a result of that. Eve did not take God's remonstrance kindly, and we are where we are as a result of that.